Okay, good morning everyone. Welcome to Wednesday's seminar, and today we are discussing programming and time with NEC and JCT, and this is being led by Richard Silver, who's the senior partner with many years of experience, so he's going to share his expertise with us. So as usual, if you have any questions that you'd like to ask Richard, you can either enter them in the Q&A tool or the chat tool in the bottom toolbar there, or if it's something very specific, you can email him. As you can see, his contact details are on the screen there, Richard Silver at silverllp.com. So without any further ado, Richard, I'll hand over to you. The floor is yours.
Thank you, Julie. Good morning, all. As you'll see from this page, my background is in construction. I've held various roles within construction companies, including senior manager, construction director, site agent even. And it's a terrible admission, but on all the projects I worked on, unfortunately not one of them, to my memory, ever completed on time. Every project obviously was delayed for reasons that were not my fault. And I think I sought in each and every occasion a full extension of time. And indeed, probably in retrospect, I probably sought extensions of time beyond the period we were actually delayed. And it's my experience that that is the norm. Nearly all jobs, unfortunately, do finish late for a whole multiplicity of reasons. And generally because of the potential for liquidated damages being levied and the additional cost associated with prolongation, it is generally the case that contractors will seek extensions of time. And what I think is very important to recognise is if one is going to get into arguments on extensions of time, the very first document that people will put onto the table to try and establish their entitlement is a programme. And all too often, parties do not give sufficient consideration to that programme until it is too late. I'm instructed at this very moment for a contractor to claim a substantial amount of extensions of time, and it is all being done retrospectively. And as is always the case, the information, the records aren't as good as one would like. I should also add, I'm a panel adjudicator, and I quite often get appointed in adjudications to consider contractors' entitlements to extension of time, and indeed I have one at the moment. And the reason I quite often get appointed is I have acted as an expert witness on a number of large projects concerning delay. So hopefully I'm going to try and give you some advice about dealing with delay generally under the NEC and JCT. When I was a contractor, we had at least 3 forms of programs. We had the program we issued to the employer. We had the program we didn't issue to the employer. And we had programs that we might issue to the subcontractors. And they were all different. And that's just pointing towards the fact that the programs have separate aims. Now, as far as delay is concerned, there may be 3 circumstances where we need a program. Number 1, if there is a potential liability for liquidated damages, we're going to need to seek extensions of time. And therefore, that program will very much assist us in showing why hopefully we were not responsible for delay, and thereby why we're entitled to extensions of time. Quite often, as soon as you've sought to avoid liquidated damages, you are also seeking to recover loss and expense for the period of prolongation, or possibly thickening costs during the contract duration. And there's again, a program will be required for that. And then the final one is that the employing party may be seeking some form of damages against the contracting party. So for example, if I'm a main contractor and I want to seek damages from a subcontractor for late completion, and thereby maybe pass down liquidated damages I'm incurring, I need to show that they were on the critical path and that they caused me to be delayed. So that may be a different program altogether. And indeed, the program I issue to show a delay against the subcontractor may be completely at odds with the program I produce to give to the employer to show I have no culpability for delay. And therefore, you can see that it's very important when producing these programs, you are mindful of what they are going to be used for. I should add that equally, for those of you who receive programs, you need to be mindful why they're being issued to you and how they may be adapted, maybe to best suit the contractor and not you. Now, the starting point when considering these programs is to consider how the contract deals with delay. Now, under JCT, we have a completion date. We may have a number of completion dates where we have sectional completion. And the traditional approach, as in JCT, is the contractor is entitled to an extension of time for any delays caused to the completion date or the sectional completion date. So quite often what you actually have to show is that the end date is likely to be delayed. Now, sometimes where these delays occur at the beginning of the program, you won't be able to actually know for sure that it will delay the completion date. But what you're going to be doing is using a program showing how many weeks you are then behind, and thereby the completion date should be projected as being the same period behind, and that's the amount of extension of time you are seeking. So it is all based upon the delay to the completion date of the works or the sections. However, NEC is different. For those of you who have attended my NEC courses, every time I go through this contract, I repeat throughout, but NEC is different. Now, NEC says a delay to the completion date is assessed as the length of time that, due to the compensation event, planned completion is later than planned completion as shown on the accepted program. So it is not that planned completion is later than the completion date. It is planned completion is later than the current planned completion on the accepted program. Now, the significance of that is if you have an accepted program and the contractor is showing them on that accepted program that at present they're going to finish 10 weeks early, but then there's a compensation event that shows that they're going to complete on time, they get 10 weeks extension of time. It is not based upon what is the delay to completion, but what is the delay to the accepted program completion date. And that is fundamental because it's going to come up possibly with a completely different answer to that under the JCT. The other thing to really notice is that everything in regards to time is based upon there being an accepted program. And there lies a problem, because in my experience, all too often on NEC projects, there is no NEC accepted program. Sometimes, but not all, the contractor, or where it is a NEC subcontract, the subcontractor has issued a program, but not always. But quite clearly under this, they must have issued a program for there to be an accepted program. The next factor is it must have all the information that the contract requires, and we're going to go through that in a moment. And then finally, it must have been accepted by the project manager, the employer, or the contractor under the subcontract. All those things have to be in place for there to be an accepted program. And it's my experience, all too not, that's not the case, which therefore causes fundamental problems in the assessment of delay. So, what is a program for? Yes, it is a management tool. Yes, it is a programming the works and monitoring progress. But ultimately, both under JCT and NEC, and I would suggest all other construction contracts, it is for making or defending a claim. Now, if you're therefore the contractor, you need to be considering what you are issuing, because, being perfectly honest, by producing a program in a certain format, you can establish a greater entitlement maybe than if you produce the program in a different way. It will dictate what you're entitled to. Similarly, if you're the employer's professional team, you need to look at that program and make sure you're happy with it. And indeed, under JCT, I would strongly suggest that you need to amend the contract to include additional provisions dealing with the format of that initial program and what should be shown on it, its reissue and amendment. The JCT doesn't do that, unlike the NEC. Now, as I said, I was in construction, and I remember very early on being told that by the contracts manager, where I was an assistant site agent, oh, right, here is the contract program. They laid it out on the table and they said, this is our contract program. We issued it at the beginning. And what you must know is that you should always monitor against this program, irrespective as to whether it is current or not. We always monitor against the contract program. And I'm sure many of you heard that, and of course it's wrong. We're going to identify when, in fact, you should be changing your program. But the starting point is what is a contract program? Nearly every program issued at the beginning of the job is called a contract program, but is that right? If one looks at the JCT, there is no such thing as a contract program referred to. It refers to a master program. If one now looks at the NEC, we have an accepted program. Nowhere in either of these forms is there a term called contract program. So what is a contract program? Well, very simply, a contract program is a program incorporated into the contract. It is a contract document. So if the contractor has produced a program post the formation of contract, having signed the contract documents, and that program is not incorporated into the contract, or if there was a tender program, which again is not incorporated into the contract, it is not a contract program. A contract program is simply one incorporated into the contract. It either is in the contract or it isn't. The ways of incorporating a program into the contract is either when you sign the documents include the program, or the program is incorporated by reference. For example, the following are the contract documents. 1, contract program dated the 1st of January, reference 1379. We can then determine if it is not a contract program. So if it is a contract program, what is the implication? What's the significance of that program? Well, ideally, we want the contract to state. We want a clause that says included at appendix such and such is contract program. This requires X, Y, and Z. It wants us to tell us what that program means. Now, quite often that's not the case. So in order to determine what the contract program is, one must look at all of the documents unless the contract says otherwise. And all too often, if there is a program incorporated, it doesn't comply with the terms of the contract. So for example, the contract program includes how you're going to carry out the works. Do you have to carry it out exactly like that? Well, if the JCT, you have a start date and a completion date, that's it. One of the key ways of showing the problems with the contract program are with subcontracts, because quite often the subcontract says you should carry out in accordance with the master program, the contract program, or otherwise, but the standard terms and conditions provide otherwise. They say you shall proceed regularly and diligently with the works and shall complete them by the completion date. It doesn't say you have to complete the works as per the program and in the sequence of the program. And there's been a lot of cases concerning this, including one concerning Mullally and Leander, where there was such a program in it. And the court said that notwithstanding that program was incorporated into the contract, it was not a contractual obligation for the subcontractor to carry out the works in that sequence. The reason for that was the program was in conflict with the other terms in the contract. So if you have a program that is going to be your baseline, what should you show on that program? Okay, these are general principles. Okay. The first thing is that ideally on the program, you should show all activities starting as early as possible. The reason for that is in order to get information, you need it as early as possible. And if it is provided as early as possible, you can progress the works as best as possible. But also, by showing all your activity as early as possible, you can claim extensions of time when those dates are not achieved. So the earlier the date you've requested the information, the earlier the date the information impacts the program if issued late. So very simply, by showing the earliest start dates as possible, this will have the biggest effect where there has been the late issue of information, thereby getting you more extensions of time. When looking at the earliest start dates, I would suggest you not only want to consider the start date of the works, but the procurement period associated with that work, including, for example, the ordering of materials, the manufacture, the delivery to site, and everything. I would strongly suggest you should be putting as much information on the program as possible. What also should be shown on the programs? The latest finish dates. Now, quite often, what you have to show is that because of the particular event, it's caused your completion date to be deferred, to be prolonged. But if there are activities which you are not being delayed by reason of any delay for which the employer is culpable, then it's shown your own delay. Why was this particular activity late? There's no entitlement to extensions of time. Clearly, it's your fault. And then we're into concurrent delays, and the employer is saying it's not cause and effect on the completion date. So again, by showing the latest finish dates possible, quite often you can explain away that the works are not behind because you can show that you've still got more time to complete the works. Next thing is you have to include on your program provisional sums. Now, be aware that under a number of contracts, including the JCT and the NEC, there are what are called defined provisional sums and undefined provisional sums. Defined provisional sums are provisional sums where you have a certain amount of information. Undefined is where you don't have sufficient information and are therefore deemed not to have allowed for programming and planning and preliminaries. So for undefined provisional sums, I would strongly suggest you should not be showing on the program at all, because you don't have to. All you should be showing are defined provisional sums. So far as those defined provisional sums are concerned, I would be showing them as early as possible on the program, and thereby the need to have an instruction on the expenditure of those provisional sums as soon as possible. So if that instruction is not issued, you can claim an extension of time and will not be in regards to the late provisional sums, it would be late instructions. The next thing is the period of provisional sums, the period shown for the bar for provisional sums. Now what I would show is maybe a minute and a half. What I'd be doing is showing the shortest duration that I can get away with for the provisional sums so that when they're instructed and expended and they show that there is a requirement for a longer period of time, again, I can claim more extensions of time. Final thing I'll be showing on program, very important, is access. Now, if you're a subcontractor in delay and it's down to you to produce the program, which is the case under the NEC, where I am in delay, I will seek access to areas you can't give me. If you can't give me, that gives me a compensation event and an entitlement to extensions of time. So again, when I'm producing a program, I'm going to look at the areas on the site identify where there may be a problem with access, and make sure I show that as early as possible on the project to potentially gain myself further extensions of time. Now, when I give this talk in front of an audience, lots of people get quite angry by these sort of statements. They think, well, you're a claims consultant, you're a lawyer, you're always looking for claims. That's not the way we do it. It's not the way to do it. I don't agree. I think it's very simple. On projects where the job goes behind, no one, as far as I'm aware, puts their hand up and says, it's my responsibility. When a job goes behind, everybody seeks to blame somebody else. Very rarely do I see an architect, an engineer, project manager saying, I have issued information late, I have varied the works, it was my problem, don't worry about submitting notices, I'll award you an extension of time. I don't think I've ever seen that. Equally, I don't think I've ever heard a contractor say, yes, we were 6 weeks behind, we're not very good, it was our fault. What always happens is each party seeks to blame the other. And when one is seeking to blame the other, the first thing you have to do is to look at the program to see who is culpable for the delay. And if I can say to you, I can produce a program that gives you a greater entitlement, do you want that program? I think the answer is always yes. So it's on that basis you need to consider the program. But the problem is that quite often contractors have planners, programmers in their organization. They're always really nice people, honest, truthful, very clever, and they always think theoretically how the works should be carried out in an ideal world. Well, number one is I've never seen a project produced and completed in accordance with an ideal world situation. Construction doesn't go that way. But more importantly, they do not look forward and see the potential problems we may encounter and try to gain us more extensions of time. So when I've worked for construction companies, quite often I sit down with the programmers who produce these lovely programs, and then I mark it, putting loads of red marks through it and change it all around to show a program which will give me the maximum entitlement. When should you revise a program? As I said, it was advised to me when I was a young person on site, you should never revise a program and should always monitor against the original program. Well, that is wrong. First point, we're on a program and we're finishing we are 3 weeks in front of program. There is then a delaying event caused by the employer that delays us for 3 weeks and puts us back on program. What's our entitlement to extension of time? Now, whether it's right or wrong, the employer, the architect, the CA will always argue you're not entitled to an extension of time because there has been no delay. So I would always show on my program that I am on time. I will never show myself in front of program to avoid those nature of arguments. So number one, when should you revise a program? When you are in front of program. Number two situation, this is a job, it's got going very well at the beginning, and we're now 5 weeks behind program, which has all been down to our own fault. We can't hide it. The problem has been issues in getting our subcontract procurement in place, starting the works, pulling foundations and the like. We are 5 weeks behind and it's our fault. A few weeks later, there is a delay event that causes a 5 weeks delay on the program. We claim an extension of time. What's going to be the response? The response is, you had your own delay of 5 weeks. This is a concurrent and secondary delay. Your initial 5 weeks was the critical and dominant delay, and therefore you're entitled to no extension of time. So when should you secondly revise a program? Where you are behind program and cannot blame somebody else. So if I am in the scenario I've just given you 5 weeks behind, I'm going to revise the program, say that we always anticipated initial problems in the ground. There was, in our view, some float at the end, so we have reprogrammed and we're now back on program. So what I've gone through is some basic principles with regards to programming. What I'm now going to do is to address the NEC particularly because it is so different. As we've already identified, under the NEC, our entitlement to extension of time is based upon the difference between our current accepted programme and our new accepted programme. And therefore, what we need to go through is the provisions dealing with accepted programmes. Here's the first clause. The accepted programme is the programme identified in the contract data. So quite often in the contract data will be a programme issued by the contracting party, which has thereby been accepted by the employer and incorporated into the contract. If that is the case, make sure that initial accepted programme is in the required format to suit your requirements. So for a contractor, you want to make sure that it gives you the maximum entitlement to extensions of time. And if you're the employer, you possibly want the opposite. If, however, and which is often the case, there is no contract accepted programme in the contract data, then there has to be one issued by the contractor within the period stated in the contract. Quite often, this will be within 2 weeks of starting the works on site. Going back to this programme, this last paragraph, the latest programme accepted by the project manager supersedes previous accepted programmes. What we're identifying here, and which you must be aware of, is that the accepted programme under the NEC is a developing document. It is not a contract programme we keep on day one and continue to monitor against. It is a whole series of programmes. And indeed, if you were to follow the contract completely to the word stipulated, the obligations set therein, as to the issues of programmes, it is possible that you need to issue a programme every day, and in some circumstances, every hour. And we'll identify why that's the case a bit later on. But the accepted programme is a developing document, and it should be not only showing the works in the future, but also the recording the works as and when they're undertaken in the past. So far as that programme is concerned, in seeking to try and ensure that the contractor issues it, we have clause 50.5 that says that where the contractor has not issued their initial accepted programme, the employer can withhold 25% of amounts otherwise due until the contractor has submitted that programme. This seeks to enforce the contractor issue a programme. I have amended this clause in the past and made an obligation to issue such a programme, applying to all the programmes under the contract, not just the initial one, in seeking to ensure that the contractor issues programmes as required under the contract, because as I've said before, quite often that's not the case. Now, what does one show on programmes? We've got a number of attendees today. I know that there was just under 200 applied to this course. Some people are from an engineering background and some are from a traditional contracting background. And there is a difference. Under engineering contracts, those of people who have worked on those projects will always expect to see a very detailed CPA, critical path analysis. Their programs are hugely detailed. Under general building contracts, the quality of programs isn't, in my experience, quite so good. Now, the new engineering construction contract is an engineering form. It was meant for engineering projects. It's produced by the ICE. And therefore, it follows the more traditional engineering form of contract in setting down in great detail what nature of information should be shown on the accepted programme. If one looks at the JCT form by contrast, it says the contractor shall issue a master programme. That's it. It's one sentence. It doesn't say when you've got to revise it and what information should be contained in it. It's really simple. But under this NEC form and in traditional engineering forms, we have a lot more information. Now, what you'll see under the NEC is not just a programme. It's method statements. It's labour and plant histograms. It's risk allowances. There's a huge amount of information that needs to be provided. There's the first page. There's the second. One hell of a lot of information. You'll see the final 2 bullet points. For each operation, a statement how the contractor plans to do the work, identifying the principal equipment and other resources which the contractor plans to use. That's part of the program. And any other information which the works information requires the contractor to show on a program submitted for acceptance. So we are not simply talking about a program, we're talking about a lot of documentation and a lot of information. We then have this express provisions dealing with revisions to those programs. We have to show on each revised program actual progress achieved on each operation and its effect upon the timing of the remaining work. How the contractor plans to deal with any delays and any other changes which the contractor proposed to make to the accepted program. So the program should show in detail all the past works carried out and all the future actions. It should be mirroring what is going on site. There should be in effect a drop down now line to be able to show each time a program is issued, where you are on program for each and every activity, how that activity is affecting the critical path, and how it's ultimately affecting the completion date. And each accepted program is compared against the last accepted program in establishing what entitlement to extension of time the contractor has in regards to notified compensation events. On that issue on compensation events, just for those of you who are not aware, unlike the JCT, the NEC does not have separate provisions for extensions of time, loss and expense, and variations. To the contrary, they are all rolled up into one called compensation events. So under the NEC, by way of example, exceptionally adverse weather conditions is a compensation event. A contractor may have an entitlement to an extension of time because of that compensation event. And if that is right, then he's also entitled to recover monies associated with that compensation event. And it's all rolled up on the basis of a quotation. It is a very, very different approach to that under JCT. Now, it was only yesterday I was in discussions with a client on a particular project where the project is not going well and it is behind program. And I asked them, because the completion date has now been exceeded, where were they in the issue of compensation events and extensions of time? And the same typical answer came back. We've agreed lots of the compensation against as to value, but as far as extension of time, we've agreed with the project manager, we'll deal with them separately. But the project manager doesn't have the authority to amend the contract revision to change it. They're going to come back to you later on down the line and say you've got no entitlement extensions of time because you've agreed the compensation events without the delay period associated. You cannot separate it out unless there's an agreement by the parties for this different approach. And that can't be with the project manager. That's got to be with the employer and recorded and evidenced. So under the NEC, do be warned, if you're dealing with compensation events, do not just deal with the quantum, deal with the time as well. As far as these revisions to the programs are concerned, we have to issue programs or revised programs when requested to do so by the PM, whenever we choose to, and at the interval stated in the contract data. And generally under the contract data, it states that you have to issue revised programs every month. So in theory, the very minimum we're going to be issuing is a program monthly. However, we also have to issue compensation events in relation to, programs in relation to compensation events. If we are saying a compensation event causes delay, we submit a quotation and we should include a program. Then in assessing the delay, we look at the program issued with the compensation event, compare it with the last accepted program, and the difference between the two as to end date is our entitlement to extensions of time. I dealt with that clause earlier. To confirm this clause, quotation for compensation event comprise proposed changes to the prices and any delay to the completion date and key dates assessed by the contractor. Contractor submits details of his assessment with each quotation. If the programme for remaining work is altered by the compensation event, the contractor includes the alteration to the accepted programme in his quotation. There's no uncertainty there. If you are claiming an extension of time because of a compensation event, you must issue a programme with your quotation showing what is the impact to the delay. And ideally, you want to be able to show a bar showing the additional time associated with the CE, being the date shown on the last accepted programme as a milestone, the new end date, red line, difference between the two is our entitlement, and all the bars above it explain how that period has been incurred. So far as these programmes are concerned, the contractor submits quotations within 3 weeks, and the project manager replies within 2 weeks. Where the project manager's received such a quotation, he's either got to accept the quotation, ask the contractor to submit a revised quotation, but providing reasons why he wants a revised quotation, or advise that the contractor will make his own assessment. Very clear. We are looking to deal with these compensation events at the time and not 6 months down the line. So those of you on the employers team as project managers, do be aware that if you don't like what the contractor is doing in their assessment of delay in their accepted programs, or the contractor is not producing programs, then it's down to you to do it. So I think the project manager has to have a good capability of producing programs, both the monitoring of the contractors and where he doesn't agree with them, producing his own. Now, what my experience is that the project manager is all too often very good at rejecting the programs, but is less able of producing their own. So let's deal with this scenario. There's been 1,000 changes to the works, 1,000 quotations submitted with 1,000 programs issued, all of which have been rejected. But there's nothing else. Project manager hasn't produced their own assessments, they haven't produced their own programs. The only record we've got is all these programs issued. Who's likely to win? So even though the contractor hasn't got any accepted programs, he's got the only programs and therefore is likely to win in any dispute. So as a rule of thumb to contractors, even where your programs are being rejected, do not stop issuing them. Keep issuing them. Where you're a project manager, if you don't like a program, revise it, ask for it in a format that you can amend, and then reissue your assessment, ideally supported with programs. But as a general rule of thumb, the party who will win under any NEC form of contract is the party with the most paperwork. We already know that under the NEC you have to issue compensation event notices and early warning notices, but equally important is the issue of programs. As I said, the PM can reject a program, but he's got to give reasons for not accepting it. There's the full 4 bullet points. You can say that it is not practicable. It's just not achievable. It's just not realistic. But if that's right and the contractor doesn't produce another one, then the PM's to do it. This is one that all too often is applicable. The program does not show all the information which the contract requires. We've already identified there's a huge amount of information that needs to be issued on that program to be compliant. It does not represent the contractor's plan realistically, or it does not comply with the scope. So if there is going to be a rejection of the program, you have to give your reasons. And if the PM does not respond, either accepting or rejecting the program, the contractor can notify the PM of that failure. And if the PM doesn't respond from receipt of that notice, then the program is deemed accepted. So I've just set down a few bullet points on the importance of the program. As I said, the accepted program is not one program, it is a series of documents which will be the very foundation of the contractor's entitlement to extensions of time. It is imperative that the contractor issues them in the format required under the contract and at the times required under the contract. The PM must therefore be aware when he takes on a project of this nature, the amount of involvement he has to have in the programming. And indeed, if, as often is the case, they're not happy with the contractor's program, they're going to actually have to do it themselves. Both parties should be keeping a very accurate record of the works that they're undertaken by way of the accepted programs. And what they are, in effect, is a time slice or window analysis. And it ought to be able to substantiate what the contractor's entitlement to extension of time is. What I've done here is just to identify some of the compensation events listed in the NEC. Obviously, changes to scope, access, but a lot of these events actually say, with reference to the contract, the accepted program. So, for example, the client does not provide something as shown on the accepted program, 60.13. That's information. So if you're going to say you're being delayed for that compensation event, what you're going to have to do is to show when you required it on the accepted program. And then when you got it, it's the difference. If you haven't got an accepted program, it's very difficult to show that it was late. And that clause actually refers to the accepted program. The same is in regards to access dates. It says the access dated in the contract data, or if later is shown on the program. It's all related back to the program. So if you're going to be claiming these extensions of time, you're going to actually have to show what is on the accepted program. It is fundamental. But that final one quite often will impact in relation to, for example, the coronavirus. It will deal with an experienced contractor would have judged the contract date to have such a small chance of occurring that it would have been unreasonable for him to allow for it. Well, if you didn't even know about the coronavirus, that's clearly one of them. Dealing with JCT, as we've identified, unlike the NEC, we're dealing with dates of possession. We have a date of possession and a date for completion, and we may have sectional completion within that contract. As far as the contractor is concerned, he is able to carry out the works in any sequence that he likes. He can start on day one and move slowly at the beginning and move much quicker at the end. He has an obligation to proceed regularly and diligently, but so far as the sequencing, he can do the works in any order that he likes, unless you've stipulated elsewhere in the contract. The obligation on the contractor is simply to complete by the completion date. And I've referred there to Glen Lyon versus the Guinness Trust. When I first started in construction, I worked on a project that we had secured. We'd been the lowest tenderer, and I've always been a cynic that says if you've priced the job lowest, you've underpriced it. But basically what had happened was we'd looked at this particular project and the tender documents had said that the contract duration should be 70 weeks. But we looked at the works and thought, we're specialists at this, we could do this much quicker, we'll price on 50. And because of that, we had 20 weeks worth of prelims we hadn't allowed for and obviously beat all our competitors. We therefore secured the project. The contractor signed provided for a 70-week completion period. However, we'd priced for 50 weeks, so we produced our first program, and what we showed on it was that we would complete within 50 weeks. What then happened was the employer didn't give us the information in the time that we needed it, and we completed later than our program. We finished in 70 weeks. So we completed exactly the period stated in the contract. We therefore sought an extension of time and were unsuccessful because you're not entitled to it any under the JCT. Under the JCT, the employer, the architect, the CA is only obliged to provide information for you to complete by the completion date or where you are behind program to meet with progress on site. He does not have to give you information to complete early. You have a right to complete early, but you cannot oblige the employer to provide you information to enable you to complete early. And there's the whole details. So what we can see is the situation is very different to the situation under the NEC. So far as JCT, common problem at the moment, is there an entitlement to extension of time for the coronavirus? We've got this case here, Clydesdale and Clifford. where it said that a flu pandemic was force majeure. So I would suggest to you, albeit there is no case law at present, that the coronavirus is likely to equally apply. But do be aware, and I really want to emphasize this, it would only be force majeure if you signed the contract before you were aware of the coronavirus. So if you are signing contracts now or any time post probably January, maybe at best February of last year, you won't have any entitlement for force majeure because you should have foreseen it. By February of last year, we were aware of the coronavirus and we were aware of the problems. We went into lockdown in March. So you would not be able to claim for extensions of time under force majeure for the coronavirus, where at the time of signing the contract, you were aware of it. We also have extensions of time for statutory powers, and therefore it is possible that the effect of the Coronavirus Act 2020, where it's implemented that there is restrictions being placed, that may generate an entitlement to an extension of time. Okay, a lot of information I've gone through. Julie, are there any questions?
There are indeed. We have 4 questions to open with. First one's someone saying that you've made reference to provisional sums being shown in the programme. Am I correct in my understanding that under NEC does not deal with provisional sums?
Not necessarily. Under the NEC, there is provision for the incorporation of a B of Q and the incorporation of SMM7 under option B and D. Where we've got option B and D, we've got a B of Q. In the contract data, it states which method of measurement is adopted. If it adopts, for example, SMM7, it thereby brings in the whole issue of instructions under provisional sums.
Okay. Next question up is, we have seen EOT issued with a caveat no cost impact. Say that both parties have agreed to this at the time. Is this contractually binding and can the contractor come back for L&E?
If there's an agreement, there's an agreement. So if you've actually agreed to it, then that agreement is binding. So the very big question is when it's been agreed, has it been agreed? Did the person agreeing it have the necessary authority and is it evidenced? Quite often in interim applications, amounts are said to be agreed, but we would argue that they're agreed on account. But if we have a letter that says the parties have agreed the following items, then they're agreed and it is very unlikely you're going to be able to get out of it.
Okay. Under the JCT, if you issue a revised programme and the trade contractor does not respond, did you just say it is deemed that they have accepted it?
Silence is never deemed as acceptance, so they can't. And the fact that you've issued it doesn't mean they've agreed to it at all. Under the trade contract, they may have no obligation to agree to it in any event. So all that you're doing is saying that I, as the contractor, want you to carry out the works in accordance with this programme. What it will be doing is possibly showing a record of where you are and problems you've encountered. But all it is a record, no more. It doesn't necessarily bind the other party to carry out and complete it, because indeed you could issue a programme showing they only had 1 day. So, albeit I don't know the exact contract, I think it's very unlikely that it include provisions for the acceptance of a programme issued by the contractor.
Okay. Someone else is saying on slide 23 of our presentation, does NEC 3 have it set out in the programme is deemed not accepted by no response from the project manager? It was NEC 4 that has reversed this, whereby no response by the project manager will incur acceptance of the programme.
It's not no response. It's a no response followed by the contractor saying you haven't responded.
Right.
And the provisions applying to that with regards to compensation event notices and quotations is in 3 as well.
Okay. If you inserted a JCT contract amendment in March 2020 to include a clause for the ability to claim EOT due to coronavirus and the contract is signed off, then will this stand?
Yes. The fact is that whatever the parties agree is what they've agreed. If they agree that you're entitled to extension of time for coronavirus, then that's what you're entitled to. The fact that you're aware of it or not is irrelevant. All we're saying is where there is no provision for coronavirus and you're looking for force majeure as part of its parameters is it was unknown. So therefore, if you sign the contract at a time when coronavirus is known, for example, today, coronavirus couldn't be under force majeure.
Okay. Someone else is saying, a council has shut down our construction contract temporarily due to coronavirus. The contract was signed when CV19 was known about. Would this be a prevention event or one of the other compensation events? Even if the contractor knew it would likely happen, could they have reasonably been expected to price accurately for it when pricing their activity schedule?
What I would say is has the current regulations with regards to construction works is those works generally can continue, notwithstanding lockdown or otherwise. So on what is being said, I would imagine that but for the employer, under the current regulations, these works could be carried out. What is happening is the employer is choosing that the works not be carried out, not because of government restrictions, but because of their own restrictions. And therefore, it is a lack of access and potentially an act of prevention by the employer.
Okay. Someone else is saying, under NEC compensation events, what if the contractor does not agree with the PMA? What happens next?
Potentially adjudication, arbitration, litigation. Very simply, a party says, I say it's £5, the employer PM says I don't want to say £10, says £2. We now disagree. Unless something happens, the PM is the one who certifies, he's the one who's going to pay you, he's the one who's going to give you whatever your entitlement is and then seek damages. If you don't like it, then your next option, unfortunately, if you can't negotiate a settlement, is to refer the matter to adjudication or, depending upon what's in the contract, arbitration or litigation. Okay.
Just on that note, we had a question pre-submitted about your best advice for avoiding dispute or preparation for claims on NEC contracts.
My advice for avoiding claims on NEC contracts. Okay. There is a lot of things in the NEC that I think are particularly good. I think the very detailed provisions for programming and planning are good. But I suppose the starting point is that the NEC, when drafted, was not put in place for your particular project. It is a standard document and doesn't match what you are going to undertake. And the NEC, quite rightly, the ICE, thereby included Z clauses. So it is my view that all contracts should be amended by Z clauses to match what the works are. Now, I think there are certain provisions within the NEC I don't like, just for example, that every compensation event and correspondence is to be issued separately. You can't do it. So I would be looking to amend the NEC in regards to the issue of information, communications, and I would also probably slightly amend the provisions on assessment of delay. And as is common, I would probably take out, if I can, the scheduler's cost components, which often happen. And I would include a lot of other provisions. But very simply, I don't think any contract in its standard form is adequate or suitable for every project. It's just not possible. It has to be amended to reflect exactly what's required and also what's required by the particular organisation. So the organisation as a local authority is going to be very different to the developer. Who's on the project, how much management input and the like. Put very simply, I think all contracts should be amended, but as to what those amendments are, it will depend upon the nature of the project.
Okay.
Call me amendments.
Right, 2 more questions coming in. One refers again, same person just wants some clarification, slide 23. Which NEC clause can be quoted for the failure of the project manager to not respond to the contractor's notification in order to treat the programme as accepted?
Okay, being perfectly honest, I'd have to quickly look through. I don't remember all the clause numbers by hand. If that person wants to know, either email me or phone me.
No problem. I can give you the contact address. We can sort that out afterwards.
Okay.
And then someone else is saying, under JCT, if we had a programme within the contract documents, and then as the employer's agent, we issued an EOT for 2 weeks, are the contractors obliged to revise and submit a new programme in line with the new completion date?
Very simply, no, unless the JCT has been amended, because there is no provisions for the issue of revised programmes post the issue of extension of time or at all. We've asked the question about amendments to the NEC. As far as the JCT is concerned, I think there has to be substantial amendments to it, not least in dealing with programming and planning, and provisions more akin to the NEC need to be brought in, including the issue of revised programmes, when those revised programmes are to be issued, and what nature of information ought to be shown on those programmes.
That's wrapped up our questions for today. So thank you to everyone for attending. Thank you very much, Richard, for sharing your expertise and time with us. As you can see on the screen there, we have some further seminars coming up. So that's actually the 2020 date. So I'll get the correct dates out to you when I send the certificates out. And in the meantime, have a great day, everyone. And we hope to see you all again soon. Thank you very much, Richard.
Thank you.